Hey everyone, welcome back to the Balanced Lens, where we examine faith, culture, and politics from a balanced perspective. One of the reasons we do this podcast is to fight extremism. You may have seen this in society already, but in the last 10 years, people have grown so polarized and so divisive over so many issues in the world today. And we hope to inject a compassionate, balanced, factual perspective into issues that are relevant today to perhaps help people see an opposing view that challenges them and ask them to reconsider how they are interpreting an issue. And so today we're talking about a very important high stakes issue. Our episode is about the Supreme Court case that could change elections forever. On April 29, 2026, in Louisiana versus Calais, the Supreme Court ruled 6-3 that the state's congressional map with a second majority black district was an unconstitutional racial gerrymander. Justice Samuel Alito on the Supreme Court wrote that the Voting Rights Act didn't require it, so race couldn't justify the lines, weakening Section 2 provisions in the Voting Rights Act against vote dilution. Now, before we begin, we need to take a step back and define a lot of terms here, because though this is an important case, it's a very complex case. And if you don't know much about how elections are conducted or districts are drawn or how the redrawing of districts can be abused, we need to define some terms. So first thing I want to define is this term gerrymandering. Now, gerrymandering is a practice of drawing electoral district boundaries in a way that gives one group an unfair advantage over another. So imagine this. Imagine a state has 10 districts and the population is split 50-50 between two parties. A neutral map might result in each party winning about 5 districts. A gerrymandered map could mean one party wins perhaps 7 or 8 districts despite receiving only half the votes. Now, there are 2 common techniques that are used in gerrymandering. One is packing. This is essentially concentrating the opposing group's voters into a small number of districts, so they only win those districts by a large majority and giving those 2 districts their votes, and the other districts votes to your own party. So that's packing. The second strategy when it comes to gerrymandering is a strategy called cracking, where you look at the opposing party and you essentially split the voters across many districts so that their votes are diluted and they essentially cannot win any districts. So these are 2 issues that courts are constantly challenging and constantly facing. Now, there's 2 different types of gerrymandering I want to talk about. Number 1 is political gerrymandering. Again, we're just defining this. This occurs when districts are drawn to favor a political party. For example, a legislator controlled by Democrats would draw or could draw districts to help Democrats win more seats, and vice versa if a legislator is controlled by Republicans. The focus is on party affiliation and not race. Now, interestingly enough, the Supreme Court ruled in Rucho versus Common Cause that claims of excessive political gerrymandering are generally not questions regarding federal courts, leaving many disputes to state courts and state legislators. So that's political gerrymandering. Now, another form of gerrymandering, and this is what this current Supreme Court case revolves around, is racial gerrymandering. This occurs when the race is the dominant factor used in drawing district lines. For example, drawing districts primarily based on whether residents are Black or Hispanic or Asian or white or any other race would be considered racial gerrymandering. Now, the result of this is often creating these oddly shaped districts that include or exclude certain racial groups, the focus being on race and not the actual party. Now, racial gerrymandering is illegal. It violates the Equal Protection Clause of the 14th Amendment. It violates the Voting Rights Act of 1965, which we're going to talk about a lot. Unlike political gerrymandering, racial gerrymandering can be challenged in federal court. Now, here's why the distinction is so difficult and why this case is complex. In many places, race and political affiliation are highly correlated. For example, Black voters in certain states often vote Democratic at high rates. White voters in many states may vote Republican at higher rates in certain regions. If map makers draw a district that heavily favors Democrats, critics could argue, well, this is political gerrymandering. Others could argue, no, race was actually the primary factor. And so the difficult job of a court is to determine which factor was the real motivation in drawing a congressional district. So again, to recap, the difference between political and racial gerrymandering. Political gerrymandering targets political parties. Racial gerrymandering targets racial groups. Political gerrymandering is both based on voting preferences. Racial gerrymandering is based solely on race. Political gerrymandering, often legal unless prohibited by state law. Racial gerrymandering can violate the Constitution or federal law. With political gerrymandering, federal courts generally avoid deciding these disputes and they go to the state level. When it comes to racial gerrymandering, federal courts regularly hear these cases. And so the two issues can often interlap, and this is why redistricting lawsuits are often some of the most complicated election law cases in the United States. And so gerrymandering is a very vast, broad, and complex topic that delves into so many issues regarding elections. Now, the final thing I want to define before we jump into this case, and again, this is a mini history lesson here. This is an issue or the definition of the Voting Rights Act of 1965. And this is core to so many issues when it comes to congressional redistricting and drawing maps at the state level. The original intent of the VRA, we'll call it, of 1965 was to enforce the 15th Amendment to the U.S. Constitution by eliminating racial discrimination in voting, especially the systematic barriers that prevented African Americans in the South from registering to vote and participating in elections. To add some historical context, after the Civil War, the 15th Amendment was passed 1870, which prohibited denying the right to vote based on race. However, Southern states engaged in many discriminatory tactics. Some of those tactics were literacy tests, making sure people could read and perform different types of academic tasks before they voted. Other barriers included poll taxes, grandfather clauses, residency requirements, outright intimidation to essentially disenfranchise Black voters despite the amendment. Now, by the mid-20th century, these Jim Crow era practices kept Black voter registration extremely low in many areas, even where Black citizens were a significant portion of the population. And so the context of this preceding the VRA is essentially systematic racism that was disenfranchised a lot of Black voters. One of the key triggers that pushed the nation across the line to actually pass this act was an event in Alabama called Bloody Sunday. You see videos of this online where state troopers violently attacked demonstrators who essentially were fighting for equality in their right to vote. And so this prompted national outrage. President Lyndon B. Johnson pushed Congress for stronger legislation. This actual legislation has some very key provisions. Number one, the VRA, it bans discriminatory practices. It eliminated these practices like literacy tests, poll taxes in state and local elections, other tests or devices used to deny voting rights. It created federal oversight. It authorized federal examiners to register voters in areas with a history of discrimination and low turnout. It enforced something called pre-clearance in Section 5 of the VRA. Here's what that did. It required certain jurisdictions with poor voting rights records or a history of discrimination or intimidation to get approval or pre-clearance before changing voting laws or procedures. So essentially, they said, hey, you need to talk to us at the federal level before you change anything. Finally, Section 2, a very important part of the VRA, and this is what a lot of courts discuss today, it prohibited any voting practice that denies or abridges the right to vote on account of race or color, essentially a nationwide ban. And so all this is important to understand as we begin talking about this specific case in Louisiana. So we're going to jump into this case and we're going to ask this question. What is the history of Louisiana congressional map since 2020 through currently where SCOTUS just looked at and issued this hearing or this proclamation in Louisiana versus Calais?
So when you think about redistricting, the people start the process of redistricting. Traditionally, it's always been post-census. So census normally comes out every 10 years. And so 2020 was the last time an official census was done. The next one will be in 2030. So as soon as the 2020 census was done, you have new numbers, right, of how many people are, what is the total number. And it's a big deal because that you may have to shift the number of delegates or representatives that each state even has based on these numbers. So it's a very big deal. And along with that, that's also the time when you get data around like racial distribution, current racial distribution in the state, et cetera, et cetera. So post the 2020 census, so here's what happened in Louisiana. Louisiana has 6 congressional districts. And if you look at their population based on the census data of 2020, about 33% of that state is black. However, historically, only 1 out of the 6 congressional seats have been majority black districts. So all throughout, they have had an underrepresentation if you purely go off the racial, the black percentage in the state. So here's what the state did. They went ahead and started redrawing the map like they normally, they did the redistricting map. But while they were redistricting, they still kept the 1 majority black district. Instead of making it 2, they just kept it as 1, like it used to traditionally be. Now, this was done even though the Democratic governor at the time, John Bell Edwards, he vetoed the map that the Republican legislature had passed. But when they had a supermajority, so they went ahead and overrid his majority, his veto, and the map passed. As soon as the map was in effect, the black voters sued under the VRA Section 2, and it was called Robinson versus Ardoin, or Robinson was Landry later. And it went to the federal court, and the federal district court and the Fifth Circuit actually concluded that it was likely violating Section 2 of the VRA due to vote dilution. So that's what happened in 2022. So once that happened, obviously it is going through the different courts at the time. The court basically said that they have to redraw the map to ensure equity. And if the state doesn't do it, they're going to risk the court doing it on their behalf. So the state went ahead and redrew the map in 2024. They created a second majority black district. And it was weird, long, irregular shaped district that, it had Shreveport to Baton Rouge in Louisiana. So it was a weirdly shaped district. It was done to make sure that there was one more district that was a majority district, a black majority district. And so this allowed this specific district, because now we have a new one, it allowed a Democrat, his name is Cleo Fields, to be elected in 2024. All right. Now, once that was passed and all is done, a group of non-black voters challenged it in the federal court system under what is called Louisiana versus Calais. And they basically said that this is racial gerrymandering, right? Like I said, remember the weird shaped district that they drew. So at that time, right, a district court kind of struck it down, and then it went to SCOTUS, it went to the Supreme Court, and they stayed the ruling for that election that was happening in 2024. So now then fast forward to last year, 2025. So Supreme Court heard the different sides earlier in the year. They did not make a decision even after the hearing. This is one of the rare occasions where the Supreme Court told the parties to go ahead and do one more study and give them a brief about how each of their arguments supported that they were not violating the 14th and 15th Amendments. So the parties had to go back, right? The non-black group, the black group, and the state, remember, at that time was siding with the black group, right? Interestingly, when they started hearing the case back in the fall, so this is fall 2025, October, back when it's in session, the state of Louisiana switched sides. They switched side and they became part of and this is very extremely rare that a party switches side in the middle of arguments. They switched sides to the non-black group, and they basically said, hey, if this is not the way to do it, you should just get rid of the entire Section 2 of VRA. This is just going back and forth. There's a lot of confusion, right? Finally, what ended up happening, and we all know this, right? The Supreme Court did rule 6-3, so it was not like borderline or anything. It was 6-3 ruling, and it struck down the remedial map that was drawn in 2024 to include the 2 black districts as unconstitutional, that it was racial gerrymandering, and that Louisiana must redraw it so that it's not a racial gerrymandering, right? So what they said was, it is okay to have race as part of your equation when you do it, but it cannot be the majority of your reason for drawing the district. It cannot be the predominant factor, right? Because now you're violating the very law that says that you should not discriminate based on race. This is why there's always been a tension between the 14th and 15th Amendment, right, which says that you have to be colorblind, right? You should be racial blind. And the VRA, which is trying to make sure that these states were trying to to be biased against the Black community. That was overridden, right? So it was enacted. The 1965 VRA and the 1982 amendment to the VRA was meant to help the black community and the minority group in general to be protected from any states or political systems violating their right and freedom to vote freely in elections.
And it's fascinating, right? Because the state essentially switched sides multiple times. You have a second district just being created to represent majority Black voters, and then essentially the state coming back and saying you can't do this. And now people look at this and say, well, is this racist? Like, what's happening? Are we just throwing minorities under the bus here? Well, it gets complex here, right? And we're going to dig deeper into this because voter dilution in a congressional district has been an issue that has come up for many decades. It's been discussed many times at the federal and state level. The majority opinion in SCOTUS cited a case called Thornburg versus Gingles to update the framework for Section 2 claims, requiring plaintiffs to disentangle race from politics. Now, we're going to go a little deep here. If you're a political nerd or you're a history nerd, you might enjoy this. Even if you don't enjoy this, it's important to understand this was not like a blanket decision based on race. There's a lot of legal complexity that is involved in this decision that SCOTUS made. So Thornburg versus Gingles, an important case in 1996 where Black voters in North Carolina, they challenged multi-member district that spread them out thinly, diluting their votes under Section 2 of the Voting Rights Act. The Supreme Court unanimously set a three-part test. These are called the Gingles factors to prove vote dilution. So these are the three tests that are used to determine, well, is the voting of a minority group actually being diluted or perhaps restricted? Number one, minorities must be large and compact enough for their own district. Number two, they must vote cohesively as a group. Number three, they must face a white majority that blocks together to usually beat their candidates. Now, the Gingles factors are only the threshold requirements. Once those three factors are met, courts do not automatically find vote dilution. They look at, quote unquote, the totality of the circumstances to determine whether minority voters have less opportunity than others to participate in the political process and, elect their preferred candidates. And so a major source for this analysis was a Senate report that accompanied the 1982 amendments to the Voting Rights Act. Courts often consider these following factors along with the three tests in Gingles. So number one is the history of official discrimination in voting, education, employment, or housing that may affect political participation. So we're looking at racism essentially in a congressional district. Is there actually discrimination that's happening at a systematic level in education and employment and housing and voting and other systems? Number two, is there racially polarized voting? Are different racial groups consistently and cohesively supporting different candidates? Number three, they look at the use of voting practices that enhance dilution, such as at-large elections, majority vote requirements, or unusual district boundaries. They look at candidate slating processes, whether minorities have been excluded from influential political organizations or endorsement processes. They look at fifthly, the effects of past discrimination that continue to hinder minority political participation. They look at political campaigns. Were there racial appeals in political campaigns? They look at the history of minority candidates in winning office. Number eight, they look at whether elected officials are responsive to the needs of minority communities. Number nine, whether a state's justification for the challenge map or practice is tenuous or weak. You can think of the Gingles test as like getting into the courthouse door. The plaintiffs first have to show that a reasonably configured minority district could exist and that voting is racially polarized. But after that, they ask all these other questions like I just enumerated above. In the real world, are minority voters actually being denied an equal opportunity to elect their preferred candidate? And so the totality of the circumstances analysis is really where judges examine the state's political history, voting patterns, and political realities to answer that question. In Louisiana's case in challenging the original congressional map, the plaintiffs argued that Black voters satisfied all three Gingles factors, meaning Louisiana was initially required under the Voting Rights Act to create a second majority Black district. Now, the tension in Louisiana versus Calais arose because the state was caught between two legal commands. On one hand, federal courts found that Gingles factors were met, and ordered Louisiana to draw a second majority Black district. On the other hand, the challengers, right, if you remember the case or have read through the case, the non-Africans argued that the legislator relied too heavily on race when creating that district, making race the predominant factor in drawing the map. In the Louisiana litigation, much of the debate centered not on whether Black voters satisfied the Gingles factors, but also on whether Louisiana could draw a second majority Black district in a way that respected traditional principles such as compactness, contiguity, preservation of communities of interest, and political subdivisions. And so all those traditional districting principles became critical when courts evaluated what Louisiana was doing and whether they could propose a remedy that was legitimate on whether race became the predominant factor in drawing the map. So, at its core, to summarize, the case became a clash between Gingles, Thornburg versus Gingles, and the Voting Rights Act versus the Constitution's limits on race-based redistricting. The Supreme Court ultimately concluded that Louisiana's chosen map crossed that constitutional line and really highlighted the increasingly difficult task of balancing both sides of these bodies of law. And so before we rush to say, well, the Supreme Court is racist or, minorities are losing all their voting rights, there is much more to this process to, dig into and learn about. And so we can take a step back here. Was the intent of, creating majority minority districts, based on race necessary in the past, considering the structural and racial problems in the US in the 20th century?
Yes, absolutely. You mentioned a few of this earlier, right? There was, within the context of what was going on, there was very low participation of Blacks, even though in 1870 we have the 14th and 15th Amendments being ratified. So what is almost a century passes, right? And there's a lot of there's an uprising happening with the population. Remember, in the 1960s, 50s, and 60s, we have got Dr. Martin Luther King, and you've got all these events that are coming, right? Because just because you pass a law, like that's the first step. You still need the hearts and minds of people to change and to adhere to the law, number one, and to adhere it with to accept it with their heart. So this was what we saw, especially in the South. You had Jim Crow laws. We've got poll taxes. We've got literacy tests. We've got violence. There is a systematic dilution of discouraging. Remember, it's not the participation in the voting itself. That was not as bad. The problem was the registration process itself is rigged against the Black population, right? So the participation was really low. We're talking at 10%, 30% in the southern states, really low. And so as soon as this law was passed, and if you look at the rates post this law, it spikes up. The participation rates in the South spikes up to 60%, above 60%. And so it's you could see the immediate impact. It was correcting an injustice. It was basically trying to bring some more clarity on the 14th and 15th Amendments and make sure that states did not wiggle their way out of adhering to the intent of those amendments in the Constitution. And so we do see, as a matter of fact, that the 1965 VRA, it increased the Black participation. There was still patterns of polarization and, voting, like racially polarized voting. It was still there. There was still like block voting by the whites against Black candidates. So all those things were happening, right? Because again, it's a process. It's not like a switch. You want to get the process going, which is what exactly happened. Then the remedy again happened in 1970, in 1982, where the amendment was passed, right? So it's not in the 1982, basically it was trying to say like, you need, as long as you can see the impact of what you're doing, you don't have to prove that there was an intent behind it necessarily. So they were trying to make sure that the effect was taken into consideration when deciding whether somebody was trying to suppress the minority votes, right? So even around this time, remember there was this concept of packing happening, right, where you pack people into different districts or you dilute them and you crack them into different districts. There are different ways they were doing it, but you can see, like if you ask me, was it important for a law like this to pass? Yes, it was. And you could see the immediate impact of the law. Okay. And if you fast forward to today, I was looking at some stats, it's really interesting. We actually have, so if you look at the US Congress, okay, we have, so in our general population, about 58% of the population is white. About 12-13% of the population is black. Okay. If you look at Congress, even though 58% of the white population is 58% of the population is white, they have 72% representation in Congress. And the blacks, they have 13% of the population, they're roughly 13% of Congress. So we have actually achieved equity for that particular race in Congress, right? But Hispanics, for example, in the population is 20%, but they're only 11% in Congress. So they're 20% of the population, 11% in Congress. Asians are 6.5% in the population, but they're only 4.5% in Congress. Same with Native Americans. So I guess if you were to zoom into African American or black equity, we have come a long way and almost achieved it from a pure numbers perspective in Congress. But then what about these other races, right? Like, so there is this tension that is always there between, does equity always mean fairness? Because there are two different concepts. Equity is important, participation is important. You need to give people chance. But fairness is not the same as equity, right? Equity means you're treating everybody the same. Fairness means you're treating everybody fairly based on what it is. So, like, for example, women are more than 50% of our population, about 51% of the entire population, but they're only 28-ish or 29% of the US Congress. So we haven't gotten to equity there. But equity doesn't always mean fairness, because you want the best people, the people with the right qualification, the right experience to lead you. So I just want people to keep that in mind as you think through the nuances. It is important to give people a chance to rise up. So I think there is a time when this was important, to give people equity, give people a chance. But at some point, if you do not untangle from that, the danger is that now you start having racial blocks. People are thinking about blocks of like how race votes, and they're treating you. You're that black. You're the black block. You're the white block. You're the Asian block. You're the Indian block. You're the Chinese block. That's dangerous, and that actually is against what our Constitution actually tries to get to. The heart of our Constitution is like, we should be blind to race, blind to color, blind to sex. We have to do it based on what is the right thing to do.
Yeah, 100% agree. And, as an Asian American, there are white people and black people and Hispanic candidates that actually represent my views better than Asian candidates, right? And I think it goes back to the point, we need to look at the character of a person, the policies they are standing on, the platforms that they are campaigning on, and ask, does this align with my worldview? As opposed to looking at a person's skin and saying, oh, we're almost the same shade, so surely they must be the right candidate to represent me. That is not a wise way to choose your political representation. But thinking about the importance of this in the past, specifically the issue of using race to create congressional districts. The principle of creating districts based on minority votes and this issue of vote dilution in the past was necessary, right? It was essentially a decades-old emergency provision to fulfill the broader purpose of the VRA and combat disenfranchised Black voters who suffered from centuries of systematic racism. And so at the time, as Biju mentioned, when hearts and minds were not seeing eye to eye on issues of race, it was important to have these districts where you had majority African American voters grouped together in districts to essentially advocate for candidates that could advocate for them in the context of an era that was immersed in racism. The act, this particular VRA, right, it aimed to translate the abstract promise of the 15th Amendment into practical reality. And it did, like Biju mentioned, dramatically increase Black voter registration, political participation. Note this, it was not originally focused on creating specific electoral outcomes like proportional representation of majority minority districts. That involved more in later amendments and court interpretations, especially the 1982 amendments to Section 2. But its primary goal was access to the ballot box free from racial discrimination. And so that leads to the last question, and an interesting question. And this is where the country is divided on. Was this the actual right decision? Are we diluting minority voters? Again, Louisiana is 33% Black, yet now only one majority Black district will exist in Louisiana. How will this shape the political landscape? Will this reduce Black representation in Congress? Was this the right thing to do?
Two views, and it was very clear in the Supreme Court ruling that there was there was no fuzziness in the level of clarity provided by both sides. So you had the critics view that was provided by Justice Kagan, and she was very clear about what she was saying. She said this fundamentally weakens Section 2 of the VRA. It enables vote dilution. It makes it hard. It like the Gingles criteria has been tightened, right? Now that you have to have not just an outcomes based, but an intent based gerrymandering happening, racial gerrymandering happening. So now she feared that the critics fear that states can now justify their map saying, no, we didn't really take race into account. It was really just meant for political purposes, right? It was a partisan gerrymandering that we were doing, which is totally fine. So the critics say that this kind of risks like entrenching a dilution of Black voting power in the South, especially where the polarization between the parties and the race is pretty high. They're worried about fewer Black representatives. They feel like we are turning back the clock, right? This is going to have a negative impact on the country. They feel like we were just getting to a good point. We are creating traction. We are moving forward. And they fear that this may take us back. That's a fear of the critics. The supporters' view, which is echoed by Justice Alito and Clarence Thomas, by the way. And FYI, Justice Clarence Thomas is a Black Supreme Court justice. Not only is he Black, he's also going to be the longest tenured Supreme Court justice in history in a couple of years. Okay, so just want the listeners to be clear about that. So this is not a white justice kind of issue or anything like that. So the supporters like Justice Alito and Thomas, they basically said this actually vindicates the 14th Amendment colorblind, race-blind criteria, that you should not do things just on the basis of race. Section 2, they argue, does not require a proportional outcomes, like you said, Dennis, but it just says that race cannot predominate without strict justification. Right? So they're saying that this is just updates outdated assumptions, right? Yes, there was a place for this in the past. Are we still in that spot? Is it time to rebalance it so we can move forward? That is what they were saying. They want to curb judicial overreach, and they're okay with the partisan gerrymandering, and they want to prioritize individual equal protection over race or group-based districting. That is a supporter's view of this. Again, from an outcome perspective, you can see right now it's happening in the country, right? Different states, they're going and they're trying to maps to see if they can get a political. Most of them are just trying to get a political advantage so that they don't lose a majority in the Congress. Like that's ultimately what I see. Honestly, people will do whatever they got to do to keep power, and that's okay, right? The partisan gerrymandering, the Supreme Court or the court system has no problem with that. But it's the question becomes, I think, and this is for our audience, for everyone to consider, it's like if race is always in the back of people's mind when they think through different things, you have to be careful, because sometimes you'll see things when they are not really there. So it's something to always be cautious about. But I mean, I'm a minority in this country, and I lived in Alabama for 6+ years. No, actually 8+ years. I have had no issues. I loved it there. I have had zero problems anywhere in Alabama. And I drove through the southern parts of Alabama, the inner parts of Alabama. I'm not saying my experience is everybody's experience. I'm just saying, like, I'm just urging audience and our listeners and everybody in this country to consider seriously, like, how far we have come, right? And is it time to turn the page? Is it time to, like, move on and stop making race as a basis of so many decisions that we make in life?
Yeah, excellent points. And I really do love that. And it's important to look at this and realize the Supreme Court did not gut voting rights. Minorities still have an opportunity to vote. It eliminated this scandalous, outdated political strategy of using voting rights language to sort congressional districts by race and protect Democratic seats. This is outdated. It was necessary in the past, but it's been manipulated. It's been used to abuse congressional maps. From another perspective, let's look at it like this. If the decision to allow a second African-American district in Louisiana was upheld based on the racial constitution of that district, essentially giving one group special consideration for voting based on race, what's to say that other classes of people, Hispanics, Asians, people with disabilities, Koreans, the LGBTQ community, people who are Catholic or Buddhist should not get preferential consideration? Why do we just consider one racial group and not consider other protected classes based on religion or disability or other races? It's also important to realize that in a democracy, there are fundamental principles that have to be preserved. And so in this case, did SCOTUS got political equality? Absolutely not. One person, one vote. Each person's vote should carry roughly equal weight. There is still political equality. Everyone has access to vote. We believe in majority rule and minority rights. This is a fundamental concept to democracy. Did the Supreme Court got that? Absolutely not. Candidates who receive the most support should generally win elections. The minority group that loses elections still should retain their legal protection and political participation right. They should have the right to nominate their candidates and campaign and have equal protection from the law. The majority gets to make policy decisions through elections. That is a byproduct of democracy. The minority retains fundamental rights and opportunity to persuade voters and become the majority in future elections. The majority can't strip away constitutional rights, free speech, religious liberty, due process, other equal protection clauses. And this was preserved in SCOTUS. SCOTUS did not take this away. This decision did not diminish free and fair elections. Voters, whether they're black or white, Republican or Democrat, still have the right to choose representation without coercion or fraud. This did not take away competitive elections. This did not take away consent of the governed. It did not take away the principle of equal opportunity to participate. It did not take away the principle of accountability, right? You still have state courts involved. You have every state now that has to, if they choose to, after every census, they still have to get their maps approved. You still have to abide by VRA. You still have to abide by, the Equal Rights Amendment and really follow the rule of law and have accountability and checks and balances. SCOTUS's decision did not diminish the rule of law. SCOTUS's decision did not diminish representation, right? Everyone is still having a chance to be represented. But if you're a minority and you don't win the election, that's simply because you are a minority. If anything now, if you're a minority living in Louisiana or any district and your preferred candidate does not win, it should force you to ask yourself, how much am I actually engaging in my political process to be a meaningful voice, to change hearts, to advocate for laws, to support candidates that I like? Many people, believe it or not, don't care about politics unless it's about the price of gas, how much money it's in their paycheck, or how the stock market is doing. But we need to move beyond that. And if you're a minority in a district, there are opportunities for you to engage in the political process, maybe sway your district and help people see a perspective that they don't have. But again, this has nothing to do with principles of democracy like political equality, majority rule, minority rights, free and fair elections, competitive elections, consent of the governed, and so on, and accountability, right? But it has everything to do with using color and only color as the basis of determining the boundaries of a congressional district. To conclude, right, as Christians, how should we respond, right? How does this affect our faith as believers in the church? People look at this case and say, without knowing the facts, will we step back into colonial America or the 1800s now? We're taking away minority rights. As a believer, right, how do we approach this issue that is polarizing?
At some point, and I think the point is now, we have to decide that we want to get past seeing everything around us through the lens of isms. I call it isms. And there are many of those, right? And I'm not trying to undermine their legitimacy. They are there. But how much of it are we just imposing versus it really being there, right? So we talked about racism. We talked about how far we have come as a country. We talked about sexism. We've talked about how far we have come as a country for that. There is classism still, right? Based on your social status, your economic status, the size of your car, the brand that you wear, the handbag that you have, the shoes you wear, right? So that's still there, right? There is ableism, right? How able are you? How skilled are you? How qualified are you? There is ageism. Hey, look at the young person. Oh, he's too old or she's too old. That's there. There is heightism, right? How tall? Oh, look how tall they are. Look how short they are. There is baldism. I have no hair, right? And my co-host does. So all these isms are there. So if I personally take a step back and I start looking at things and analyzing it comprehensively by applying simple first principles, what do I see and what do I conclude? Here's what I think it is. It's a matter of the heart. We have to investigate inside our hearts, reach deep within and do an honest and thorough assessment. That's where the problem is, right? Inside your heart, inside your mind, your thoughts, right? The traumas that you've had, the experiences that you have, we have to do a deep introspection and see clearly like what is going on. Because until we transform our heart, until our heart is transformed, these things that come outwardly in the form of racism or any of the isms I mentioned, by the way. So there will be a lot of people who are proudly saying that they have conquered racism, yet they do some other isms. That's why I'm saying it's not you. We are trying to put Band-Aid on the symptoms that we are seeing. These are all symptoms. The common problem is the heart. And from a Christian perspective, this is exactly what God wanted to solve when he sent his son Jesus to die for our sins, to forgive us, to reconcile us with him, fill us with his Holy Spirit so we can be transformed from within, right? And when we get transformed from within, the Bible talks about the fruits of the Spirit, which is full of love, joy, peace, patience, kindness, goodness, humility, faithfulness, self-control. You listen to you see how God himself, through Jesus, treated people when he was on this earth, how he was kind, how he did not have any of these isms around him, right? That's what he came to transform our lives into. This is my belief, right? And until we get there, people keep fighting over the symptoms and who is more symptomatic than others, right? It's like saying that, like I have a little sin and you have more sin. Like we are just comparing degrees of sin at this point, and the wrong ones at that. We need to get past it. And as a Christian, this is in my belief is that the way to solve it is in the heart, and the only person who can solve problems at the heart level is Christ himself through the Holy Spirit that is living in us.
Yeah, so true. And I think it's important to, as believers, to recognize that there is division over this. People are upset. I mean, this is going to be an issue that is going to be a major topic on the news for the next few months leading up to the midterm election. And so you need to look at yourself from both sides of this. If you're on the side where maybe you're a white person and you're listening to this and you're Republican, I say this from someone who's a Republican. I voted for Republicans almost my whole life because that's the party my values have aligned with in the last 15 or 20 years. That's not to say I always will, but if you're looking at this and you're Republican, you're shouting victory. This is awesome. This is great. But I think Christ calls us to have empathy. You need to look at the other side, who are minority voters, perhaps, or people that are Democrat who see this as a major loss for freedom, and ask, why is this a painful issue? Can I understand issues of race better? Can I understand issues of the urban city better? Can I understand issues of immigration better by listening to people and their stories and seeing why they vote for candidates in the way they do, and why issues that we think are right are necessarily not the perspective they see. Now, flipping that, if you're on the other side and you're a minority and you think, oh my gosh, the world is ending and people are taking away my rights, I want you to think about what Biju said. We need to escape isms. We need to escape the sensational memes we see in the media and the one-liners, and get back to the facts of the case. Are African Americans losing rights? No. Are minorities losing the right to have competitive elections or equal opportunity to participate in the law? Are we losing accountability or rule of law? Did SCOTUS rule against minority rights? No, none of that happened. I think we need to take a step back and ask, what are the actual facts of this case? Why did SCOTUS rule in the way they did? And how can I balance myself on the actual facts of the case as a believer? and trust in the providence of God to guide my country. You should also be led to pray for your country, right? The Bible encourages us to pray for our leaders. You should be praying for your president, praying for Congress, whether you like them or not, praying for the Senate, praying for the Supreme Court. If you believe that God is on his throne, surely he can change hearts and change minds, and prayer is an important aspect of that. So, as believers, right, we need to love, we need to empathize, we need to be proactive, we need to pray, regardless of which side of this issue you're on. What we should not do is say, hey, you're my cousin and you're a Republican. I'm never going to talk to you again because you're a terrorist. You shouldn't look at someone who's maybe a Democrat and say, well, your party has been doing this for decades and we still don't have Republicans in the New England states and your party's a bunch of fools and terrorists. That's the whole point of this podcast. Is to look at perspectives from another angle and hopefully draw you into Christ-like love and unity. And so we encourage you, come back for our next episode. Our next episode will be exciting. We plan to do it next week. Like and subscribe and tune in. And if you have any comments, add them to our social media accounts. And we'd love to hear from you. Thanks, everyone.